Happy Friday and happy Valentine's Day. My name is Wendy Witt. I'm an immigration attorney in Dallas, Texas. I help people cross the border legally so they can live the American dream. Thank you for joining today's Q&A. Today I'm going to be talking about the new public charge rule, which is going to go into effect on February 24th. I believe out of all the changes that have taken place in immigration in the last few years, this new public charge rule is going to affect more American families than any other change. If you are a person who's an American citizen or you live here permanently and you're what we call a green card holder, and you're trying to help your spouse, a child, your mom, your dad, brothers and sisters get residency in the United States, and you haven't filed a case yet, you are going to be impacted by this new rule. It is going to prevent probably hundreds of thousands of cases from being approved in the next few years alone. The people that are going to be most affected by this soon are people who are living in the United States as green card holders or citizens, and they are about to file a case for a spouse or a parent to adjust their status to permanent resident. That means the person that they're going to sponsor is already here in the United States. They already have a relationship, and they're just getting ready to put their paperwork in and start. If you are a person who's a citizen or green card holder, and let's say, for example, you got married recently, and your spouse is not a green card holder, they're not a citizen, so you know you need to do something about their immigration status. And if you've been putting this off, what you need to do right now is to hang up your phone, turn this off, and call an immigration attorney that you know or already trust, and talk to them and see if they can start working on your case immediately. We have about 1 week left to get cases ready to file. In my office, we've already gotten everything except a couple of cases out. If that's you, you've been contacted, you know what you've got to do to get back to us. And we are going to get all of the pending cases that we have in our office filed and postmarked by Saturday so that they're not going to be impacted by the public rule. This is going to be huge for our clients because they are most likely to get their cases approved, and they're not going to have to worry about all of these changes. If you are not my client and you're about to, you need to file a case and you haven't done it, you need to contact an immigration attorney, get someone on your case right now. You cannot afford to wait any longer. And I mean afford literally, because this change of the law is going to come with increase in immigration fees. It's going to come with all immigration attorneys are going to have to raise their rates in order to do all of the new work that's going to be required. And cases are probably going to take a lot longer. I think what people really need to understand is that it's not just that your case is going to be more expensive if you don't get it done in time, or that your case is going to take longer. What's going to happen is that your relative who's here in the United States, if they don't have any kind of status to fall back on, and you file this case under the new rules and you're not successful, and they find that your relative is a public charge, there is a real risk that that person is going to be put into removal proceedings and deported from the United States. So it's not just a matter of you lose your case. A person who's been found to be a public charge is what they call not admissible to the U.S. That means that you can be removed and you can be barred from reentering. So it's very serious. If you're watching this video and it's weeks later and it's too late, the best thing that you can do is to contact an immigration attorney, meet with them, have them take a look at your overall financial situation, your relative situation, and assess it and see how high your risk really is. If things are okay and we can make a strong case that you're not a public charge, then by all means, we would recommend that you go forward even under the changes. But the days of just whipping out a form, filling it in by hand, and mailing this off and hoping for the best, those are over. People who do that are going to have a really high risk of getting their relatives deported, and we don't want to see that. Just a little bit more about the public charge rule, in case you're hearing about it for the first time. On January 27th, 2020, the Supreme Court lifted a nationwide injunction that was preventing this rule, which it was announced for several months, but now it was on hold at what attorneys call an injunction, and now that's been lifted. So On February 24th, the new rule is going to go into effect. Maybe ask, what is a public charge? How do I know if I'm a public charge? A public charge is what immigration attorneys we call, it's a ground of inadmissibility. It means that you could be denied a green card, you could be denied a visa, or any other type of admission to the U.S. Because the government has found that you are either already dependent on some type of government aid, or you're likely to become dependent on aid in the future. There are some exceptions to the public charge rule. Some of the exceptions right now are asylees, refugees. If you're under one of those categories, you don't have to worry. A U visa holder applicant, a T visa holder applicant, you're exempt. If you're already a permanent resident and you're in the United States, you're also exempt. You don't have to worry. However, if you are a permanent resident and you're outside the U.S. and you've been gone longer than 6 months, you probably need to plan to come back before February 24th, because if you stay outside more than 6 months, you're going to be subject to the new rule too. That means even if you've already got the green card, they're going to make you apply to make sure that you don't fall under this category. And if you're found to fall under the category, they're not going to let you renew or get a new green card to come back to the U.S. This rule does not apply to people applying for citizenship. Now, there's some drawbacks to the rule and the type of information that you're going to have to disclose if you do fall that could cause some problems in your citizenship application years later, but that's really not a topic that I'm going to talk about today. Some of the things that immigration is now going to look at to determine if you are a public charge, when you're making their decision about denying your case based just on this, it's going to be your age, your education background, whether you have ever applied for any type of public benefit in the United States in the past, your credit score, your English proficiency. This is a big one. If you don't speak English, you're probably not watching this, but if you have a relative that you're trying to sponsor who doesn't speak English, this is something that you can actually help them improve. You're not going to, there are a lot of these things you can't change. You can't change your age. You can't change, for example, what your health is like, but you could change how well you speak and understand English. The change is going to also, it's not just going to be a change in the law, but there's actually going to be changes in the requirements for filing the cases, paperwork, documents that are going to have to be put forward that were never asked for before. They have put in the rule something that they call a payment of a bond. It's a type of process where you are not going to be able to overcome the public charge finding, but they will allow you to put forth a certain amount of money for the government to hold in case you do actually try to draw a public benefit. Right now they're saying that the minimum amount of a bond is going to be $8,100, and it will be highly discretionary. I would be really surprised if this becomes a thing that we're actually able to do. There's already bonds in the immigration context for people applying for visas. It's almost impossible to get the embassies to issue it. I don't know that it's going to be any easier to get immigration to offer you a bond. It would be much easier for them to just deny your case. If you have a case that you already filed and you have a receipt notice that shows that for example, your I-485 was already accepted, then you don't need to worry about this. This doesn't apply to you as long as that receipt notice is dated before February 24th, 2020. If you're rushing to get packages, say you're another attorney and got cases ready to go, as long as you get these postmarked before February 24th, 2020, they are going to, basically their version of the mailbox rule is going to be in effect. So many of us will be working on next Friday and Saturday trying to get the last few of these out the door. If you're watching this much later and the public charge has already gone into effect, it's too late to do anything. I will have more videos coming out about the impact of this rule, and I will post links to them here so you can get some help for that in the future. But anyway, once again, thank you for joining me. I'm Wendy Witt, immigration attorney in Dallas. I help people cross borders legally so they can live the American dream. If you have questions, if you missed this video, you can post your questions in the comment. I'll be logging on until President's Day to post answers. If you know anyone who might benefit from this information, please like and share this video with them. That'll help them to learn more, and it helps me get this important information out to the people who need it. Thank you so much for joining me. Goodbye.